Hello, wonderful people. Welcome back. Here I am once more to break your bubble. That bubble of preconceived notion that creates limitation of growth, which gives birth to the inability to see that there's a bigger world and actual better contentions and positions to wield in any contractual nature. The bubble people stay in, where they say, show me the wet ink signature. If you don't show me the wet ink signature, the contract is not valid. 2, being that you only have to be the holder in due course to be able to enforce a given contract. We're going to break those bubbles now, because often you will find that the people who speak of UCC, or those who speak of these two specific contentions, they themselves actually don't read the language of the UCC or sit down and actually do some self-reflection of the UCC. And here's a caveat. If you're here listening to this with the intent of taking a joyride as a position of expressing your own bigot or hate, where you're taking a stance where you say people who make reference to UCC are doing something wrong, or that they all fall under one category, take that trash of a state of mind, that hateful mind, take it somewhere else. The videos dawn on, except for value and the clarity and the misunderstanding that people have on it, the 2 parts. You will find some comments down there that are just filthy. Not necessarily that people were disappointed that what they've learned is not necessarily right, but more so I'm realizing there are actually other pockets of people who just have hate in their heart, whereby they themselves lack the capacity to actually comprehend these things. Therefore, they expect that no one else can ever understand or ever be able to put it to use. Therefore, the ones that are misguided are perceived by this small pocket of people as being either irresponsible or they try to make fun of them. My thing is, if someone is misguided, you should not be making fun of them. You should not be labeling them. You should not be trying to do the same thing tortfeasors are doing to the everyday man. That just shows that you are even in a far worse position than the one misguided trying their best to get it. Because someone making the wrong assertion of how something worked is bad enough. But someone who doesn't know as better as the one making a wrong assertion, now pointing at the one making a wrong assertion and trying to make fun of them, is even worse. If you have a hateful state of mind and you're trying to use this video to say, oh yeah, here's a proof that some of those people don't like following the law, take that BS of a trash of a state of mind, take it out of here. Yes, it's important to point to someone that they don't know what the hell they're doing. Because sometimes in today's world, people have to hear that for them to realize that they're living in la la land. But extending it to the point of just trying to throw everyone in the blanket that they don't follow the law just because of some misunderstanding, that's stagnation of its own. Because all you're doing at that point is reinforcing feud. If you're going to point out that something is not right with someone's state of mind, then show them the right way. Don't turn it into feud. You go into these social media, you see people speaking about, oh, more say they don't follow the laws. Somehow there's a pocket of people out here who just carry this state of mind. I say that the ones running about what they think status is, whether they call themselves one thing or the other, and the ones contending against those people, I say both of you are in the same boat. You're both unaware of how things really work, and you both have hate in both of your hearts, and that's precisely what's prevented both of you from being able to figure out how these things really work. Snap back into reality. Throw out the window your own filthy bias as to how you want reality to work or what you think it's about, and actually look at the foundational principles that's been here since time immemorial. So to those who think they figured out what UCC is, even though out of all the speculation they throw about, they never really give you any reference to it, it's just really speculation. On the one hand, Speculation that what ink signature is required in order for a contract to be valid. Speculation that you have to be the holder in due course in order to be able to enforce any given contract. And these terms they use, holder in due course, promissory note, these are uniform commercial code terms. And uniform commercial code is an actual thing that's abided by when it comes to contract law. But these people just use this buzzwords and actually don't know its true function. If truly you actually care for how things work and you really want things to work for you, rather than wasting your time with all these conjectures and social media, then listen carefully, because this is something all those people, they either don't know this, or if they do, they simply won't tell you. The more they clarify these truths to you, the more you come closer to being free from their chain of speculation, which is the limitation of significance that they can ever have. So long as they keep speculating, they will keep having the follower who only knows to follow. They will keep having those type of followers follow them. That gives them spiritual energy, that gives them ego boost outside of real life. They will keep lying to you, and you will keep convincing yourself of the lie as a reality. I'm here to break all that bubble when it comes to your misunderstanding. And if there's misunderstanding, that is embryonic stage for incompetence. And if you're incompetent and you're an adult in today's world and you start to put things on pen and paper, sending it to all these corporations, telling them do this, do that, you're wasting ink, you're wasting paper, you're wasting monies to mail things out, you're wasting time. Because the longer time goes on, the more you now have to convince yourself that what you've done is right. No different than someone in a screwed up relationship. You know, obviously the relationship is real bad, but you've spent so much time dedicated into it. Now you now have to convince yourself of the lie of a reality that you're living in. That, oh, it's all right. But really, it's actually really getting worse. Information, knowledge, wisdom is no different. You have to build a certain type of relationship with information. When you begin to absorb information from varying degrees or different types of people, you are, believe it or not, you are actually establishing a relationship with that information. A relationship that you get emotionally attached to, despite someone giving you the truth, which might be hard at first when you hear it. But at the end, if you're true to yourself, you see the truth in black and white. Listen carefully. UCC 3-308. Uniform Commercial Code exists on state level, each state, with exception of few states, with slightly varying degree verbiage. But for the most part, the same subsection, you will find the same subsection entertaining the same principle in most of the states, if you're not looking at the general version. But for the sake of uniformity, without having to go through all the 50 plus states UCC, we'll be using the general one that you can easily find. UCC 3-308, proof of signatures and status as holder in due course. A, in an action with respect to an instrument. You click instrument, it takes you to UCC 3-104. Negotiable instrument. But let's not make any mistake here. This instrument speaks regarding promissory note. Now there's negotiable instrument and there's non-negotiable instruments. Here we're speaking about negotiable instruments. And when you start to look at non-negotiable instruments, the same principles apply, but with some varying degrees of sophistication. Instrument tells you it means an unconditional promise or order to pay, aka promissory note, a fixed amount of money with or without interest or other charges described in a promise or order. If, and then it lists the requirement of basic promissory note. So you want to know how to create a promissory note? Follow these three basic standards. Yeah. There's international law on the creation of promissory note and all that. But all those words on those unicentral convention of promissory note can really be summarized in these three basic items. That's not what we're speaking of here. What we're looking at first is what instrument means. Instrument is a negotiable instrument. A note, a check, a cashier's check, teller's check, traveler's check, certificate of deposit. Now that we know what instrument is, let's go back to 308. And then the action meaning any circumstance where anyone intends to enforce with respect to instrument. If you want to enforce a promissory note, these are the things involved in it, specific to signatures and the status of holder in due course. This action can be formal in a proceeding, whether it be a special proceeding or not. Special proceeding is how you collect things, such as judgment. So say a court order says, hey, defendant, pay this guy $3 million. That's an order, no different than a check saying pay to the order of so-and-so. A court order, same thing. So long as there's monetary value attached to that judgment, it falls under this category. Therefore, this action mentioned within the first few sentences of 3-308 is inclusive of that. But it's not limited to it. It also includes, as we've shown, promissory notes. As you deal with information, always have a multifaceted state of mind and see the totality in commerce. Many people will tell you court is bank. The details and subtleties involved in that and how they can link it as they read the obvious things that everyone know about or hear the buzzwords, they can never correlate that to you because people think from an isolated perspective, and that hurts their ability and relationship with this thing they call information. Therefore, they're never able to put it to use. So are there deeper details when it comes to judgments and court orders when it comes to UCC? Of course there are, but we're not going there. What we're here to clarify, remember, it's the contention that people say you need a wet ink signature to enforce a contract or a promissory note, because that's usually the issue. A third-party debt collector, you owe this so-and-so money, pay up. Yeah, there's something wrong with that if you see that happening. But what you're putting on that pen and paper as to what you say the reason is, that's causing you to tell them they cannot come and ask you for monies. It's the wrong contention. And here's why. In an action with respect to an instrument, the authenticity, remember, according to the stages of evidence, there's the scope of an evidence, there's admissibility of evidence, there's authenticity of evidence, and there's an exception, which we went over in this video. The same principles apply herein because they are telling you the principles of evidence. When they use this word authenticity, they're going straight into the standardizes and maxims dealing with evidence, affirmed and reaffirmed by rules of evidence, state or federal. So again, I trust you've watched some of these previous videos. That's why I always put these thumbnails as I speak of these things to let you know, look, go watch this video for any of what I'm about to continuously say, or the words involved in information we're reading, for it to really make sense. Otherwise, you're doing yourself a disservice. In an action with respect to instrument, the authenticity of and authority to make each signature on the instrument is admitted, like an evidence will be admitted, unless specifically denied in the pleading. So now it's telling you if something is wrong with that note, you have to deny it. But then there are different types of denials. The most common one is an affirmative defense. And then each denial has to have a reason. Now, you don't necessarily have to explain it in greater details because the rules of civil procedure tells you can do a general denial. But even if you do a general denial, there has to be some basic reason to it. So it gives you the premise. Whenever anyone intends to enforce a note, the signature on the note is by default admitted. Meaning by default, whatever signature is on the face is admitted until you do something, which is denial. Each signature in the instrument is admitted unless specifically denied in pleadings. So it tells you, look, by default, signatures are deemed to be admissible, and there's no dispute as to it unless you say or speak up otherwise. That's the first clause. It then goes on to say, if the validity of a signature is denied in the pleading, the burden of establishing validity is on the person claiming validity. So in order for you to now shift burden of proof that whoever signed that note being enforced against you, or if you are the one bringing a claim, in order for you to assert the claim properly, you have to deny that that signature is valid. And then it shifts the burden of proof on them to prove that it's valid. But the question now is, according to the UCC, what are the fixed criteria of what makes signature valid? Because you might have read this first part of this second sentence to say, yes, that's what I'm doing. I'm shifting the burden of proof by saying that wet ink signature is required. Okay, good. But are you sure? All right, whatever your response to that is, let's keep reading. If the validity of signature is denied in the pleading, which is what you are supposed to do, the burden of establishing validity is on the person claiming validity. But the signature is presumed to be authenticated and authorized unless the action is to enforce the liability of the purported signer, and the signer is dead or incompetent at the time of the trial of the issue of validity of the signature. What this second part just told you is, you can shift burden of proof of validity of signature so long as the signature, or under the condition that the signature is to enforce the liability of someone who's dead or incompetent, because obviously they will say it's authentic. So when you shift the burden of proof, the UCC has a confines on how signatures can be invalidated, and that confine is if you're saying, look, the one who signed this is dead, therefore you cannot be enforcing it, or the one who signed this is incompetent. The UCC has a confines on how signatures can be invalidated, and that confine is if you're saying, look, the one who signed this is dead, therefore you cannot be enforcing it, or the one who signed this is incompetent. The UCC has a confines on how signatures can be invalidated, and that confine is if you're saying, look, the one who signed this is dead, therefore you cannot be enforcing it, or the one who signed this is incompetent, whether it's a minor by chronological age, or minor by some mental illness, or minor by inability to know or enforce the contract. Of the different ways that a signature can be challenged, according to the Uniform Commercial Code, remember, UCC 3 governs promissory notes, UCC 9 governs collaterals and other things like CDOs and mortgages. UCC dealing with promissory notes is telling you that signature to that thing. Now, there are other sections that deals with challenging signatures, but even those do not speak about wet ink signature. They speak about other intricate things attached to other things. But the more common ones and the more easier to comprehend are these two things. If someone is dead and their signature is on that note, or they are incompetent. So now you're telling this other parties to say, show me the wet ink signature. Automatically, you waive the ability to assert or deny the fact that the one who signed it, aka you, were not given meaningful disclosure, for instance, according to Truth in Lending Act. Therefore, you were incompetent. You did not make a well-informed decision in signing that. You're not making that assertion. You waived it. And you're not asserting that. Don't a lot of people say that Ens Ligas is a dead entity? These same people that would tell you Ens Ligas is a dead entity do not read the specific part of the UCC that tells you that you can actually assert that whoever signed that thing is dead. Because the Ens Ligas is a creature of law. But now the issue comes in that, are you really dead now if you are asserting it? Well, there's an issue of represented person, authorized parties, which all these people who speak about UCC or being a secure party, they go on about authorized representatives, right? So now when these people come to you say, hey, pay up, and you're writing them a letter to say, show me the wet ink signature, you see that you're completely speaking about something not even acknowledged by the UCC or other principles or elements of contracts. Again, don't people who go on about the legal this is not yours, your mother was an informant, it was birth, doctor at sea, it was not yours, it's a dead entity. Don't they say it's a dead entity, it's a dead entity, it's a dead entity? The UCC affirms the fact that you can assert such a claim to deny the validity of a signature in a note. You can assert incompetence, no different than the whole birth certificate and your inability to have entered into that contract in the first place, which is what they're all looking to go into. It's right there in its face. And even if you don't want to go that far back, which a video was done on the principles of Baby Act, because the reality is there is no such thing as Baby Act. There is no such federal or state legislature as Baby Act. Wherever people have gotten that from, I don't know, but they never questioned the fact that, well, where is this thing? Let me look it up myself. There's no such thing as a Baby Act. That Baby Act, what people loosely call Baby Act, is actually a doctrine that we went over in this video. That is just a layman's term for it. If the validity of a signature is denied in the pleading, which you should do, but the problem is you're doing it wrong. The burden of establishing validity is on the person claiming validity, but the signature is presumed to be authentic and authorized. They're letting you know, yeah, you can deny it, but it is still presumed to be authorized and valid. Unless your denial is to enforce, aka the action is to enforce the liability of the purported signer, and the signer is dead or incompetent at the time of the trial of the issue of validity of signature. Meaning these are the two most powerful stands you can assert when it comes to the validity of a signature in a promissory note. These are the two most powerful stands you can assert when it comes to the validity of a signature. These are the two most powerful stands you can assert when it comes to the validity of a signature. Again, repetition is the way the mind really gets something. Here's the question to you again. All these people are certain that Inlegas is a dead entity, it's a creature of law, it's not alive, it's not flesh and blood. Do they corroborate this part of UCC with promissory note and that entity they call Inlegas that's dead? All these people saying I did not sign the birth certificate, how come they don't corroborate the fact that they don't know all the terms and conditions to that promissory note and simply claim incompetence? According to UCC 3-308, it is extremely amusing when you go on these social media pages and you just read all these things people are going on about. And then they fall into the hand of scammers, because those scammers themselves know that those everyday men reading all these speculations, listening to other speculators on social media and all these PDFs after PDFs, using buzzwords of titles and quote status. These scammers know most people are clueless too. They're all seeking instant gratification. So they fall into the hands of those who are wolves and vampires, and they forever get traumatized. Some of them lose hope. Whereas in truth, the black and white is right here as to what you need to do in corroboration to the readily available information that all these people already know. As simple as it is. It's mind-blowing. In fact, I come across so many people who have been scammed out of their money, out of their time. I mean, there are people out here are getting others to open credit union bank accounts and get them to sign some non-disclosure agreement. And then they leave the people with tens of thousands of dollars of debt and messed up credit. These scammers run away, and the one who are scammed from all these social media groups, because of shame, they don't want to speak up. And they go to other people trying to fix the issue. Few videos will be done on that, revealing how these scammers do these things to people. But the only way a scammer can scam you is if you don't know these basic principles and you're busy running around with thousands of PDFs going on about intellectual masturbation about some SPC, or whatever other status you want to call yourself, but you don't know these basic things as to how things work. But don't worry though, a little bit at a time, clarity will be revealed. If an action to enforce the instrument is brought against a person as the undisclosed principal, remember, we mentioned about authorized person because, well, if you're here now, certain that the one signing it was dead, then who are you? Well, you are the undisclosed principal. So if an action to enforce the instrument is brought against a person as the undisclosed principal of a person, so now they're speaking of two different parties. One being the undisclosed principal, two being of, meaning relating to a person. That a person they're speaking of here is his legis. If an action to enforce instrument is brought against a person as the undisclosed principal of a person who signed the instrument as a party to the instrument. Now, this doesn't necessarily have to be the ins legis. It can be other circumstances that are in so many varying degrees. But we're only going to look at this from the scope of the limitation that people have and bring them and pull them up from that dead, rotten grave that they're in. And, you know, kind of brush them up a little bit and say, all right, now you can walk on your own 2 feet. If an action to enforce the instrument is brought against a person as the undisclosed principal of a person, don't all these other people going about person being a corporate entity, even though there's also a natural person, and all these laws say that natural persons can be held liable against these obligations of contract, but they always want to restrict person to just being artificial and nothing more. Well, if that's the case, then the UCC is telling you that there can be a representative party of a person. They refer to it as undisclosed principal, meaning while you're there signing that note in a closing table, no one really knows about you. You're just invincible. You're just there as a medium to carry out the life of what they're doing. And hopefully you can remain a slave to just keep paying them premium called monthly bills that they use as the premium for the CDOs on the market. If an action to enforce the instrument is brought against a person as the undisclosed principal of a person who signed the instrument as a party to the instrument, the plaintiff has the burden of establishing that the defendant is liable on the instrument as a represented person. This represented person is the legis, and you are the principal of that person who is being represented. If an action to enforce the instrument is brought against a person as the undisclosed principal, meaning they're always going to sue you as though you are that ins legis. Most of these people speculating to have that part right, don't they? Where they try to separate flesh and blood. But you are the undisclosed principles that you sign on behalf of it as its authorized representative. That's the underlying presumption that UCC 3-308 affirms and acknowledges. If an action to enforce the instrument is brought against a person as the undisclosed principal of a person who signed the instrument as a party to the instrument, the plaintiff has the burden to establish. Now remember, this plaintiff can be you or they. But usually, you know, the tortfeasors are always going to offense. They sue you through foreclosure and things like that. The plaintiff has the burden of establishing that the defendant is liable on the instrument as a represented person under 3-402A. And 3-402A deals with exactly the issue of someone representing another man by signing on their behalf, aka principal of a person. 3-402, signature by representative. This is what you are always presumed to do every time you sign, whenever you give out that social security or anything relating to that ins legis. Don't people say that you are deemed to be the authorized representative? This is where they're getting the presumption of that from. In case you read a lot of PDFs and a lot of SPC crap that really doesn't give you the source. Here it is. If a person acting or purporting to act, meaning they know that you can probably be doing it on purpose, or there's just a presumption by operation, meaning an implied contract, meaning a constructive trust. If a person is acting or purporting to act as a representative, signs an instrument, aka promissory note, by signing either the name of the represented person, by signing the legal's name, or the name of the signer, or in your name, whatever, however you want to sign. The represented person is bound by the signature to the same extent the represented person would be bound if the signature were on a simple contract. That's self-explanatory. No need to even go into the details. It's clear in its face as to what it is. If the represented person is bound, the signature of the representative is the, quote, authorized signature of the represented person, meaning an authorized representative. And the represented person is liable in the instrument, whether or not identified in the instrument. Now let's go back. This first section, 3-3088, tells you, look, if you want to deal with any validity of signature, you have to raise the issue that the one who signed was dead or incompetent. Where people get the contention of giving the wet ink signature, otherwise it's null and void, where they get that from, even they cannot tell you or show you the source of it. That's them facing away from the true contention they're supposed to be bringing up. Despite them knowing that this legist is dead, they fail to read these things that clearly tells you, look, since you know it's dead, you know you can raise that up as an affirmative defense to deny the validity of a signature, right? Because you're held against it as an authorized representative. And you can claim incompetence. Because the reality is that most people are actually incompetent as to the extent, origin, and details of that promissory note. All these things favor you, but people are not looking here at all. It behooves me. It's past due time this is revealed. When you sit in these social media sites and you read all these things, someone asks a question or someone just, every now and then there's always that one man or woman who just posts an entire book as though they're saying something special. They use a bunch of sophisticated words, and you realize very quickly, despite them having said all those things in those text posts on these social media sites, they really said nothing. How many thousands of people will read posts like that and at the end of the day get nothing out of it? They'll wake up the next morning and not know how to actually fix their problem on pen and paper. That's why people are quick to seek after templates, because really they don't know what the hell to do. They say, just hand me some information and I'll just mail it out and just hope it works and hope somebody responds. Reality does not work that way. And even if you're going to throw some paper at somebody and those papers don't hold these foundational principles and it's talking about some other contention completely separate from operation of what is recognized according to commerce, aka Uniform Commercial Code, someone has lied to you, or you have lied to yourself, and you're now intending to convince someone else of that lie. Snap back into reality. When you make the contention of a wet ink signature, you're lying to yourself, and you're hoping someone accepts that lie as a reality. Instead, that's the solution that's been explained to you, based on a premise even you are readily aware of. That's the continuation and perfection of what you think you already know about Ensligas being dead. It's right there. Put it to use when it comes to challenging the signature and notes. Moving on to the second contention that people make when they say you have to be the holder in due course to be able to enforce a note. If you've done an IPO, or if you've really truly accessed the value of that birth certificate and all its intricate details, beyond all the pipe dream people are fed that you just get this billions or millions in your bank account, but you actually put in work, you would know that you don't have to be a holder in due course to be able to enforce a note, because all that is required for anyone else to enforce a note is the private right and obligation of contract that third parties don't have to know about, but the ones who enter into it. You, representative of that Ensligas John Doe, you are considered a third party, aka a volunteer. And there's a maxim of equity that says equity does not aid a volunteer. A promissory note deals with the equitable value itself. Once they do a valuation, then they bundle it up into CDO called securitization, and then they put it on the market called hypothecation. And whatever else they do to it privately as to how they cash out on it. You're not involved in that. You're just a third party. You just live in a la-la land. But you have an idea that something is going on of that nature, don't you? So now you want to challenge the issue. You're just upset they're using your credit to trade in the market. But you don't even know the right contention to even start bringing things up. Well, it's been mentioned here. Start there. You want to know more details? We speak about it on Patreon. So now let's pop that bubble of people thinking you have to be the quote holder in due course to enforce a note. Remember, this 3-308 deals with two main specific things: proof of signature and status of holder in due course. We went into proof of signature. Now let's go into holder in due course. B, if the validity of signatures is admitted or proved and there is compliance with subsection A, a plaintiff producing the instrument is entitled to payment if the plaintiff proves entitlement to enforce the instrument under subsection 3-301. Unless, and by the way, 3-301 literally just tells you, look, anyone who has been rightfully assigned that note can enforce it. Let's go to 3-301. Person entitled to enforce an instrument means the holder of the instrument. 2, a non-holder in possession of the instrument who has the right of a holder, meaning it's been assigned to them, that we've went over in these videos. Or 3, a person not in possession of the instrument who is entitled to enforce the instrument pursuant to 3-309, 3-418B. A person may be a person entitled to enforce the instrument even though the person is not the owner of the instrument or is in wrongful possession of the instrument. You're entitled to enforce it even if you are in wrongful possession of the instrument. This is the reason why many people are using that birth certificate like a harlot, because of 3-301. So if you merely just possess it, which is one of the requirements to perfect the security interest, you can enforce it. Even if you don't possess it, but you have some other allonge, aka assignment documents, that says you have the right and interest to that value of that note, then you can enforce it too. See how these third parties come in to say, hey, come give us some money. These are the premise you must know before you begin to talk a bunch of trash on a piece of paper. Can you talk trash on a piece of paper? Absolutely. Should you? Absolutely. But know what you're talking about first is what I say. That way, when you do begin to talk trash, they will take you serious, because now you're dealing with the true matter rather than some conjecture, rather than some intellectual masturbation that even you don't even know its source, why, or how. Remember, liability compels performance, and where liability does not compel performance, value does. When you make conjecture on a piece of paper based on what some social media posts or what someone has just told you flamboyantly on some social media posts or wherever else, without actually showing you the reality of how it works, you're still just playing around. You're not a reality. You're in a unicorn, rainbow, and leprechaun land, which, hey, there's nothing wrong with that. But these people will make you lose value very quick. And they will make you hurt if you're delusional. Because that's part of your responsibility in reality, to refine your soul through learning. And if you spend your time fucking around, you will keep hurting. Now let's go back. These are realities that all these people going on about status correction will not tell you. Because if they begin to tell you these things, you will realize that all this SPC stuff is just the delusional trash that's been put out there to distract people from things we're speaking of in this video. The reality. They don't want you looking at this. Because now you know the rules to the game. And All that mental energy you've been spending on trash, if you just put it into this, you'll see your way out. You'll be able to free yourself. If the validity of signatures is admitted or proved and there is compliance with subsection a plaintiff producing the instrument, meaning you can't even begin to speak about who can enforce it unless the signature is properly ratified. And if the signature is properly ratified, cool. Then a plaintiff producing the instrument is entitled to payment if the plaintiff proves entitlement to enforce the instrument under 3-301, meaning, are you a holder? Do you have something that shows your right to that document? Believe it or not, all these people trying to go into the birth certificate, their own account, treasurer, direct, so-and-so, this ties into the birth certificate too. Because the same matter, if you're saying that you were a child and you then signed a birth certificate, do you not know you're stripping yourself away from the ability to even have any equitable interest in it? But 3-301 tells you that you can still have an equitable interest in it. Right. So this not only applies to just mortgage issues with people presuming you to be a debtor, this also applies to that thing everyone is chasing after, the birth certificate. Once you really get information, you will see everything so clear, not from an isolated perspective. A plaintiff producing an instrument is entitled to payment if the plaintiff proves entitlement to enforce the instrument under section 3-301, unless, meaning you can enforce any given instrument, whatever form it comes in, so long as you have possession of it, which is one of the ways you perfect the security interest. Or even if you don't have possession of it, you have some type of document that says you have the right to use it a certain way. Unless the defendant, meaning the opposing end. Remember, when you use this word plaintiff or defendant, you can be on the either end. So see yourself in either position based on the circumstance. Unless the defendant proves a defense or claim in recoupment. See this term recoupment? There's also another remedy that has its own world that a separate video will be dedicated to. It's the direct counterattack to being able to enforce anything when it comes to money. Because now someone else has an equitable interest to take it, which then triggers this buzzword people throw around called subrogation. If a defense or claim in recoupment is proved, the right to, and part of this recoupment is set off, in case you're wondering, which we go over in this Patreon video, and the preview of it is posted on YouTube. If a defense or claim in recoupment is proved, the right to payment of the plaintiff is subject to the defense or claim, except to the extent the plaintiff proves the plaintiff has right of a holder in due course, which are not subject to defense or claim. Marinate on these basic truths, basic facts, and basic principles that's been hidden from you through intellectual masturbation by those who pretend to be assisting you, but are just leading you on year after year after year after year. Read black and white, comprehend it. And see, I always end these videos by saying best of luck, because most people actually need it. I say best of luck to the majority of the people because most people, with a very few exceptions that listen to these videos, most of them are followers. If you're a follower in today's world, luck is all you're going to need. If you're a follower in this world, you will always suffer. You will always be misled, because that shepherd leading you needs you to survive, needs you to keep kissing their ass, needs you to keep rubbing them, buttering them up, needs you to keep hailing them as your God. But still, they're just leading you on year after year after year. You're getting older, but you're still stuck in the same stage. You're still waiting for your God to come hand you something. Yet these black and white are right here, and they're not revealing it to you. Well, there it is. Go free yourself. A step at a time does it, though, because so much damage has been done to people's mind. When you start to reveal information, they go through a withdrawal stage. You have to be considerate. But the least you cannot say is someone is not clarifying these truths by explanation and actually taking you directly to the source of it. That these people leading you on year after year will not show you or tell you, but they'll brag though. They will brag and tell you they're showing you something special. But in reality, it's just part of the hype train. Until next time, take care. Best of luck.
I have a Patreon page, and I'm inviting you to come join. Are you interested in discharge? We show everything about how it's done and my own experience. Consistent posts are made explaining many things regarding said discharge. Many will seek and simply wouldn't find. Those dealing with mortgage issue or want to know more about it, we speak of it. For those dealing with basic stuff like traffic issues, we speak about the solution, and I show it from my own experiences and how I permanently prevent any such issues. Those worrying about trust, different types of trust, we go over so many things consistently regarding trust. We show the IRS manuals. Those who are interested in suing and making money through debt collection or other means, we go over it. We show it. I show my own settlement checks and the things that I've done as a personal experience. Those interested in banking, we show subtle details and intricacies of the things that I have learned. For those interested in other things like the IRS forms and how to put it to use, we show it, we explain the details. For those interested in court-related matters and intricacies, we always show it. For those interested in the spiritual aspect of things and how it works, we show and explain it. Those with child support matters, we explain and we show everything in detail also. Great puzzle pieces that can never be found in other social media platforms, but we explain it all as it relates to many different things. For those interested in express trusts and the issue of how not qualifying for taxation, which I call debunking, how it relates to any other type of trust or any other affairs, and how you can intertwine your affairs into the different types of discharge that exist and lack of qualification for taxation. Speak about it. The truth about really recusing attorneys and the whole foreign agent registration and attorney lawyer number, we speak about it. Speak about how to really bring about juries, and some of the comment section asks good questions and greater answers are given. Speak about how to get and use tax exemptions for vehicle use and sales. You don't have to belong to some organization. You can actually get yours according to the language of the legislature within your state. Go over the details that a lot of people mentor about regarding Article 1, Article 3. What really makes a court? It's not limited to just your paperwork. Most people don't know. We go over business matters for those with actual businesses, S Corp, C Corp, LLCs, those who are business minded and those who make money. Go over other things that a lot of people don't know, functions internationally. We speak about a lot of other spiritual related matters. Details on how to bring criminal charges, what it truly means to bring criminal charges, what a bill of particulars is, how to recuse a judge, details of the parliamentary rules in court and legislature, different things about standard of evidence and burden of proof, different things that a lot of people will speak of. Discovery. But did you know there are 6 types of discoveries? You know how to intertwine your LLCs and S Corps with an express trust, how to not make them taxable. Do you know when Trinity versus Pagliaro really is involved? Do you know how to use your home as a home office? And the many details involved. Go over the injunction and how to enforce the different types of injunctions that exist. The intricacies of how data brokers exist and how they steal information. Not just the credit bureaus, but many data brokers and how you can prevent them. We go over grants, getting grants. We go over issues and solutions of CPN and how they're created. There are about 6 or 4 to 5 different parts that were created. We go over caveats where people say sue them, but they don't really know. We go over the things to do after you sue them. We go over the issues of privacy and technology. All the whole thing about perfection of security interest, UCC, and how to use it and how to monetize the birth certificate, all that. We go over the details. There are a lot of principles and doctrines people don't know about that we go over. Go over how to really do the copyright and the details involved in it. Go over how to simply do a trademark. It's far more easier than you think. All these people telling you go to a trademark office, do this, write this letter. It's not that difficult. Go over how to fill out the GSA bond box at a time, and so many more. How to get settlement checks, how to put your vehicle in a trust. I show you from my own experiences, form for form, step by step. We go over the different types of relief to be granted, the type of relief you seek, invokes the type of jurisdiction that you fall under. All these people speaking about chancery, equity, at law, common law, the relief that you seek is directly tied to the type of jurisdiction. You go over the CPN, how it's created. Go over how to obtain bonds, where to do it. Go over different types of discharge and some more. We explain each of those types of discharge. We explain how trademark and copyright is affiliated with asset protection. We go over how to prove trust. We go over different types of fraud. We go over the importance that many people will never know. So many more. I show my own experiences in the audio calls from court cases of how I get different types of settlement checks. Go over different types of discharge. There's so much more that it can't even completely be spoken of here regarding trust. We go over how to create it step by step, and many more things that will never be shown on YouTube or any other platforms. Go over other principles that people don't know about. When they speak about statute of limitation, well, fraud does have a statute of limitation, but do you know how to subvert it? As to why that phrase fraud has no statute of limitation to bring it to life, most people don't know. There's so many things that we speak about. We speak about how to garnish people's checks and people's property. There's a form that you use for that. People don't know about it. Speak about details regarding foreign trustees. Speak about spiritual related matters. And on the Instagram page, if you get to join, come on over. There's also a Facebook page where questions and answers are posted and other reminder links to certain videos are shown. Until next time, take care. Best of luck.